which is, I just hate those people, but because they lived the dream. All right. And so today, now I know we posted that Rick is going to address the probate and short sales. I'd love for you to speak to forbearance, Rick, today. And then of course, we're just going to field whatever questions you guys want, right, Rick? That sounds about right.
Absolutely.
See how agreeable he is? Don't you want him on your side? So Rick, I am seriously just hand it over to you, bud. Thank you.
Great. Well, I appreciate the opportunity to be here. Sorry, it's not in person. I will do my best managing the technology. Are there other people in the room with us? I can't tell.
You have got 11. There's 11 of us. Great.
Well, as usual, I would prefer to allow people to ask questions as they occur to them, preferably about what we're talking about. But if there are other questions that might be of interest, I have no problem being interrupted and talking about those questions. Is that the way we're going to do it?
Sounds good to me. You're the boss.
Okay. So Brenda Lee did an excellent job of introducing me. I'll add a few more details. I have a law firm. We're focused on all things real estate, which is real estate itself, probate, estate planning, and corporate work. We don't know how to do anything else. It's myself, plus I have 5 attorneys that work for me, an additional 5 staff members. And I got my start in real estate when I was in law school. I started working for a real estate developer. I was in-house counsel for this developer for 10 years, where I was able to learn a lot about real estate development and construction. While I was there, I developed almost 750 lots for the people that I work for, including condominiums, site condominiums, platted subs, apartments, manufactured home communities. And on the side, they would let me do work for smaller developments. And I developed almost another 250 lots on my own or with partners outside of where I worked. I also built many commercial buildings. I built a couple of mobile gas stations, a couple two-time childcare facilities, a Tim Hortons, a Walgreens, 2 assisted livings, and oversaw the rehabilitation of many buildings, commercial buildings. They're both retail, light industrial, and office. And the gentleman that I worked for would allow me to be involved in all aspects. So from writing the letter of intent for raw land, to the purchase agreement, to doing all the presentation work before the municipality, working on with the bank to get money, raising private equity, getting entitlements from the municipality to actually develop the property, and then hiring the contractors. And it really gave me a really great background. In fact, I thought I was going to be a real estate developer, and that was it. And then the crash happened, and that brought me back to earth. And I opened up my law firm, and I was very fortunate to be patronized by realtors. They were nice enough to send me their clients, starting with short sales, one of the topics we'll talk about today. And it allowed my family to survive that unpleasant downturn. And now things have come roaring back in the real estate for everyone, me too. And now I get to focus on all things real estate. And we still get some short sales, so we'll talk about it. Maybe there'll be some more, we'll see. But it's real estate's been good to me. Even when it's been bad, it still came back. It's always there, and it excites me. I own real estate, not a ton, but I own some rental homes. I own a duplex. I invest in a couple hotels and some apartment buildings, etc. And I find every aspect of it intoxicating. That might sound a little ridiculous, but I think real estate is fantastic. So with that said, let's start with short sales. So what is a short sale? A short sale is selling a property for less than what's owed. That might sound a little ridiculous in today's market, as I hear anecdotal stories of people putting in, offers that exceed the ask by several $1,000s. Waiving inspections, waiving contingencies, and then still losing out. But that's the case right now. I think there's a chance we're going to see an uptick in short sales. I don't think it's going to be anywhere near the way it was before, which is good. That the level of short sales we had before undermined consumer confidence, was not good for the market. But I think you might see some now because there are many, many people who can't afford their homes based on government programs or moratoriums. Their foreclosures aren't happening. And I think that there might very well be an extension that could last all the way through this year. Although I don't know if that'll be the case. It currently doesn't go that far. And pardon me, I think when banks are allowed to foreclose again, I think you're going to see some foreclosures. Now, will everybody that's in trouble go into foreclosure? Maybe, but I think those that aren't going to be able to get themselves out, they'll sell. And maybe they sell for a profit, maybe they don't. Oftentimes, homes where people can't afford the mortgage, they don't keep them up. They're not able to keep them up. And it is possible that you see where a home, at least the debt owed on a home, exceeds the fair market value. It's effectively upside down. And in those cases, a short sale might make a lot of sense for an individual. A short sale at its core is where a lender, or potentially lenders, if there's a first and a second, will agree to allow the sale of the property to take place and for the lenders to receive less than what's owed. And in return, the lender releases the borrower in full for the entire obligation. So as an example, somebody owes $150,000 on their first mortgage and the property sells for $145,000. Well, that's $5,000 less than what's owed. But of course, we have transactional costs. Most importantly, real estate commissions. We have transfer taxes. We have title insurance. So a house that sells for $145,000, in all likelihood, the net is probably $130,000, $131,000 approximately. And that would be anywhere from $19,000 to $20,000 less than what's owed. If evidence is provided to a bank that they find to be sufficient, and evidence that the debtor, the borrower, the owner can't afford to pay the difference, in most situations, we've had success getting the banks to agree to take this lesser amount as payment in full and to do so in writing. At this point, we've done more than 4,000 short sales. So it's something that we know well. Admittedly, it's just a trickle right now, which is not a bad thing. But I still have the same staff. People still know the same things. We still have the connections at the banks. So if and when this becomes more common, we're prepared to assist people. So what is the bank looking for? Is it looking for somebody just saying, hey, I can't afford it. I don't want to pay, which oftentimes is a motivation. I'm getting divorced. I don't want the home. I just want a clean start. What the bank is looking for is a demonstration that your expenses are equal to, or at least close to, your income. It doesn't mean you're not paying your bills, but what generally a bank is looking for is a situation in which you're not able to stockpile money. Maybe you're putting a little in a 401k, maybe you're putting a little bit in an IRA, but you're not just putting money in the bank every month and watching it build up in your savings account. And what I found over all these years, since we first started doing short sales, now it's been 12, I think it's our 13th year, is, and it's surprising, or it was surprising, now it's not, since I know about it, and that is the banks don't expect that somebody is in serious financial turmoil. Now, we've had those clients. They've total job loss, catastrophic illness, horrible things. The moneymaker in the family passes away. And those things happen, and they're really sad when they do. But I would tell you, of all the short sales we've done, that's 5% maybe of our clients for short sales. The vast majority to the outside world look like they're doing okay. They got a car, or they got 2 cars for 2 drivers. It's a dual income family. The house looks okay. Things from the outside look all right. Now on the inside, they're living paycheck to paycheck. But living paycheck to paycheck, there's some people living paycheck to paycheck, and they're stuck eating ramen noodles and rice. And I'm not trying to make light of it, but they're in dire straits. And there are other people living, quote unquote, paycheck to paycheck. And you're like, well, they got a nice car, they got a nice house, their kids play sports. And I would tell you that's the more common scenario. And the point is that for someone to do a short sale, they don't have to be in dire straits, at least not the way many people think. Simply having, not that much in savings outside of retirement, because the banks generally don't look at retirement. They might ask you about it, but they don't consider it. And so in that situation, a lot of people, whether they lease their car or they're buying their car, they don't have a lot of equity in it. Obviously, you don't have equity in your house. We're talking about a short sale. And so for most people on a balance sheet, they don't look that strong financially. And that is typically enough to convince a bank to accept a short sale. What's the positives of doing a short sale? Well, the most obvious one is that the debtor is free of the obligation. So we'll go back to my example. They're going to net $131,000 from the sale. The bank forgives the $19,000. That means the borrower got away with not paying $19,000 of the mortgage. They did lose their home. It got sold. Lose is not quite the right term, but they gave up their home or sold their home. But they get out from under that debt and they get a fresh start.
Does that hurt their ability to apply for a loan again with another financial institution if they have like a short sale in their recent past? Or does it hurt your credit really bad? Like, is there anything bad that happens by doing a short sale?
That was perfectly timed.
Huh?
Well done. Thank you.
Very, very well done.
Keep tossing me the softballs. I'll do my best. Yes, it does impact the borrower. Yes, it will impact the borrower's ability to get another mortgage, at least right away. Each lender is different, but I think you're going to typically find that for a period of 2 to 3 years, lenders will not provide financing to a short seller. Now, those are not federal mandates. That's just what the banking industry has determined as to their level of comfort. Could that change? Sure. Will it change? I don't know. If it changes, could it be worse? Yeah, it's possible. I doubt it would be more stringent. In other words, I doubt that it would go from 2 to 3 years where you really can't get a mortgage to 3 to 4 years or 4 to 5 years. It could happen, but I don't really foresee that. But yeah, you're not going to be able to get another loan right away. As far as credit, you're going to get an impact to your credit. Credit really is comprised of 2 things. It's your credit score and your credit history. Your credit score is a rolling 24-month look back. So what happened to you in the last 24 months? Did you neglect to pay cable? Were you late on a Visa bill? Did you, not make this payment or that payment, or etc. And if it happened within the 24 months previous to that, or more recently, it will reflect in your credit score. When you do a short sale, we see credit scores impacted from as much as 150 points for someone that's got an 800 or an 820 score, to as little as 60 or 70 points. Maybe somebody that's already got a credit score of, somewhere in the high 500s. I don't know the algorithm that they use for the credit reporting companies. I can't tell you what the direct impact is, but I can tell you that it will affect your credit score. It will also your credit report. How long will it be in your credit report? It will show up for 7 years. Wait a minute, Rick, you just said 2 to 3 years is how long it would impact you on your ability to get a loan. Then you just said 7 years. I did. What's important to note is that the fact that something shows up in your credit report does not mean that it's negatively impacting your ability to obtain a loan. As an example, if you file bankruptcy, it shows up on your credit report for 10 years. It's the only thing that shows up for 10 years. Well, you may know, maybe firsthand, maybe by friends, people that have filed bankruptcy and have gotten mortgages much sooner than 10 years after they went bankrupt. It's not because the lender was blind and couldn't see it, or that someone pulled a fast one on the lender. The lender, although they could see it on the credit report, at some point, they no longer consider that a negative factor for considering the extension of credit. And that's exactly what happens with the short sale. So 2 years later, the lender can still see you did a short sale 2 years and a day ago. But the lender no longer considers that a negative for their underwriting when considering you as a borrower. Each lender is different. But I can tell you that I have never, ever seen a lender consider a short sale for the 7-year period. In fact, I've never heard of anyone having trouble getting a loan because of the short sale. You know, you could have other challenges that happen, after the short sale, but the short sale alone is a factor. I have not been told by any of my clients, past clients, that is, that they've been affected or impacted for more than 3 years. Again, I'm not saying impossible. I'm just saying anecdotally, I've never heard that, which is, of course, 3 years is significantly less than the 7 years. It shows up on your credit score. So there are some negatives to doing a short sale. You know, to me, it's, you get a clean start, but maybe clean starts a little strong. You get you get the chance to get out from under the debt. It's the most responsible way to get rid of the debt when you can't afford it. And yes, you got to wait, but you put it behind you, and hopefully you become a buyer again, which most homeowners, especially when they have to sell their home under duress, want to become homeowners again. And their question, after they accept that this is their path, if it is, then the next question is, how quickly can I be a buyer again? Even for those people who are unemployed and facing great challenges, that seems to be the number one question we get. So yes, you have to wait, but most people are focused on buying again. And in my experience, it's 2 to 3 years. There are other negative potential consequences.
Rick, Matt has a question for you. Matt, just unmute yourself.
Yeah, just kind of like tying in, I started in 2010, so it was right when all the short sales and foreclosures was really ramping up. One of the biggest questions I had from a potential short sale seller is, well, why don't I just let it go to foreclosure? I'm going to lose the house anyways. What's the benefit of doing a short sale? To which I would tell them the biggest benefit is you get your debt wiped out. We're on a foreclosure. And I don't know if you were good plan on getting into this at all or not, but what's the rules as far as when lenders can still go after somebody who does a foreclosure, if there was a, you know, if it's sold short at the auction, things like that? Can you go into that a little bit?
I can. Matt, thank you for the excellent question. Your answer was spot on. In a foreclosure, the lender takes the home back and it sells. The fact that the lender took the home back and sells it does not mean that all of the debt is forgiven. In a short sale, it is a negotiated resolution in which the bank agrees to release you. And quite honestly, if the bank wouldn't agree, which does happen occasionally, very infrequently, but it does happen. If the bank doesn't release you, then as an owner, borrower, seller, there is almost no benefit in doing a short sale at that point. Banks realize that, which is why the vast majority of the time they release you. But if you don't do a short sale and the bank has to take your property, the bank then sells or has the sheriff's sale conducted. If the property at the sheriff's sale sells for less than the debt, so we'll use my example that it sells for $145. make it easy numbers. And you owe 150, the bank has the ability, as of the date of the sale, to sue that borrower debtor for that $5,000 plus any accrued interest, because there will be accrued interest during this process, for a period of 6 years. Now contrast that with a short sale. You get away from the debt, and the bank gives up all ability in writing to sue you for any deficiency. In addition, we talked about credit score, and we talked about credit report. That foreclosure will show up in your credit report. In my experience, talking to lenders and having clients talk to me about their experiences after a short sale and or a foreclosure, that foreclosure would impact somebody's ability to buy a new home, or at least obtain financing to buy a new home, for 3 to 5 years. So that's an additional negative consequence associated with doing nothing and letting the house go. Did that answer your question, Matt?
Yep, he's shaking his head. Yep.
Good. Let's see, what other aspects of a short sale would I talk about? Tax consequences, I think I was going to talk about. So when debt is forgiven in a short sale, the lender will issue a 1099-C. And the C stands for debt cancellation. And that is a 1099, which means it's just like you made this amount of money for the debt that is forgiven. The government has, or the Internal Revenue Code, I believe it's 954. It's Form 954. And it is a form that a debtor who receives this 1099-C can fill out. And as long as the amount of debt forgiven, so we'll go back to my example, 150 owed, sells for 130, sells at 145, the bank gets 131, they forgive 19,000. Debtor does a short sale, debtor gets this 1099-C, it's in the amount of 19,000. As long as the debtor can show that they invested 19,000 in that house by down payment, by repair, by upgrade, etc. And when I say show, that's actually too strong. As long as the borrower claims, and I'm not, this isn't a wink, wink, make it up, but as long as the borrower claims that they had that much money invested in the property in those various aspects, then the buyer is forgiven for any tax liability associated with that 1099-C. The logic being that you lost 19,000, the 1099 is effectively stating you just got a gift of 19,000, so they cancel each other out. And in most instances, that's the case, that the amount of forgiven debt is equal to or less than the amount that the homeowner had invested in the property. If that's not the case, and it's pretty rare that it's not the case, but when it's not the case, the other possibility for relief that a debtor can seek is that the debtor is insolvent, which is an Internal Revenue Code term. And what it means on its face is that the debtor owes more than what they have. And it's a relatively simple calculation. It should be performed by a CPA, but it's the sum total of your debts compared to the sum total of your assets. And if your debts exceed your assets, you're insolvent. And on that basis, you are forgiven from the debt. Now that applies to any debt. It doesn't just have to be debt from a short sale. Any debt obligation that, any obligation of income, like from a 1099, it doesn't have to be from a short sale, it could be from other attributes. Being insolvent allows a taxpayer to avoid paying taxes. Now, that's not something that I determine, that's something a CPA determines. And rarely in my experience does that become necessary because, as I said, most people's basis in their home exceeds the amount of debt forgiven, but that is another aspect to be considered. Other questions about short sales?
You have nothing in the chat.
Okay.
So your impression is that we're going to potentially see short sales again? And when we do, what is our path?
So
Do we
I do
call
think there's
you? Do we list it? What do we do?
So I do think there's a chance of seeing short sales again in a much smaller basis than we saw before. For people that want to work with us, and we work with realtors, we're really sort of, I look at the realtor as the quarterback in these transactions, and they bring in, players that they need. For short sales, we do all the negotiation when, of course, asked to do so. We'll speak to the client. We'll talk to them about taxes, about credit impacts, about if they're a good candidate, what's a likely outcome, any other aspects of it. And if the client wants to go forward, they will sign a fee agreement with us. The fee agreement says that we are paid, my law firm that is, we are paid $3,500 if A, the short sale is approved, whether it's one or two loans, and B, if the short sale actually is consummated, so it's got to be approved.
Right.
And of course, if it's not approved, then there's nothing to talk about. Or if it's approved and the lender doesn't forgive the entire debt, there's nothing to talk about because the borrower shouldn't do it. So it's got to be approved, and the closing has to occur, which means the seller could back out because the short sale addendum will say it's subject to the lender approving and the seller accepting the terms of such approval. So the lender or the seller, can put the kibosh on the transaction anytime they want. But if it's approved and if it closes, and if the bank doesn't pay us in full, which happens at least half the time or more, then the client has to pay us the difference. When we get it approved, the client can see right there in writing, A, that they're released from the debt, and B, how much the bank is paying of our fee. So if a client said, well, wait a minute, Rick, Chase Bank's only paying $2,000 of your fee. I don't want to pay you that $1,500. The client has the right to not move forward with the short sale. I can tell you in the 4,000 plus short sales we've done, we have never, ever had a client not move forward because they owe us some portion of the fee. I believe that that's because we do a very good job of communicating with the client. We set expectations in the beginning before they ever make a determination if they want to work with us in conjunction with their realtor. And by the end, they understand the benefits of the short sale. And even though nobody would want to pay me $1,500, which I get, if we've done our job properly, the client understands it's still worth going forward. The benefits are there and they pay us, but it's totally up to the client. We don't make them do it. We don't strong arm them. We don't do anything. They can walk free of any obligation, but that's never happened. As far as how to start the process, I think it's most beneficial to bring us in at the beginning. So if you go on a listing and you find out it's going to be a short sale, or even before you go on a listing, sometimes people will have us kind of be use us to almost qualify their client. I'm not saying it has to be that way, but they'll say, hey, I've looked at the comps. I think you might be a short sale. When we are involved in short sales, we bring in this law firm. Why don't you talk to them so you can ask every question? It's private conversation. You say anything you want to this attorney. Not going to charge you based on our relationship with them, my office's relationship with his office, and ask your questions and let them tell you. And if you think there's a fit, then I'll come out and we'll talk about listing your property. Or, because I know that happens, but I don't know if that's really the most common way it happens. The other way is that you go out and meet with the client. You tell it's a short sale. You say, look, it's going to be short. I mean, there's just no way it's not going to be short. Why don't you talk to this attorney? I think you're going to want their services because you're going to want to make sure, I know what I'm doing in real estate. I know how to market it. I know how to get the best offer. I know how to get the fastest offer, but I'm not an attorney. I'm not, designed, my business isn't designed to work with lenders and negotiate legal terms and finance terms. You need somebody. And so this is who I'd recommend. As far as exactly what's said at those meetings, I leave that up to the salespeople because that's what they do.
Well, I'm going to
But
tell
that's
you,
typically how.
yeah, I'm going to tell you something that we used to do our own short sales back in the day and work so hard. It really drains you as you try and follow up in these files. They ask for information that you've already provided. You've got a new asset manager you're dealing with. There's so much aggravation. So instead, the best plan really is to send them to a short sale attorney. And of course, Rick is who I recommend because of this very good reason. And this is the one that always took the seller to Rick's direction. And it was the fact that they have the contacts. There's a tremendous amount of red tape that you go through in this short sale process, but Bunny and that team that Rick has in play, they have the contacts. Like when Bunny picks up the phone to make a call into a bank, she knows who to talk to at that bank. You know what I mean? It isn't like talking to the guy at the end of the totem pole and see if we can get something to get done. No, they know the people to talk to. So I just found that it's been my experience that it just works out better and they get results. And so it's a very easy thing to ask them to come over and talk with Rick. Our job is to assess what the value of the property is, where it's going to be the highest realistic price that this house is going to sell for. And that's an important word to add in there, that realistic. Okay. We always say that we want to get the highest price, but we're looking for the highest realistic price. And if it's determined that the highest realistic price is going to make this property a short sale property, then you do want to give them the opportunity to talk to Rick. Rick, is there a fee from you to consult for them to decide if they want to do this? Do you charge a fee for this consulting?
Absolutely not.
Yeah.
No fee charged.
Yeah, no fee.
Our fee is 100% contingent. We've aligned ourselves on model, which is that we get paid if there's success. So we all succeed together. They get their sale, you get paid your commissions you deserve, and we get paid our fee, hopefully from the bank, by the way, or nobody succeeds. I saw a question come in about, do we provide a BPO? Broker's price opinion is done by a broker hired by the lender. We can provide cons, but we typically don't do that. We find that banks will accept anywhere as little as 90 to maybe 88% of what they think the property is worth. That's about the most tolerance that they'll show. And if there's a discrepancy about value, at that point, then we'll ask the listing agent to provide a BPO and comps to support the offers that have been provided, or maybe better yet, the selling agent. But that's when we will present that kind of information to a lender. But otherwise, the lender will do their own independent valuation. And of course, hopefully it comes back and matches within the tolerance of what the offer is that's been presented. As far as offers go, the offer that's presented is the one that's selected. And I'm not trying to be cute or funny about it, but it doesn't have to be the highest offer. Many times it is, but as you guys know, the highest offer isn't always the best offer. In a short sale, because the seller is getting nothing, they don't really care if it sells for 145 or 142.5 or 140. That all looks the same, which is zero in their pocket. And so it is often the decision making, or at least influence of the realtor that says, look, this looks like the most solid buyer. I know who their lender is. I know who their agent is. I know whatever or whatever's being told to you. And so oftentimes the highest offer isn't necessarily the best offer. You want to get to the finish line. And those couple $1,000 differences, or if it's a bigger property, a $5,000 or $10,000 difference, etc., they don't mean anything because they're not of any benefit to the seller. It's just who's going to get across the finish line. So that's something to consider. From a listing strategy, if I was listing a short sale, we would oftentimes suggest that you do a comparative market analysis and list the property for approximately 120% of what you think it's worth. Because, of course, there are sometimes people out there that value it more than you do. You catch the right person and they say, well, I don't care what comps say. I think it's worth this much more. The idea of listing it that high is that if someone shows up, great. Maybe it's not even a short sale. But if it doesn't sell, we recommend dropping it at about 5% approximately every 2 weeks and doing that on a systematic basis. And the idea is that there'll be these intervals of 2 weeks where the price is lower. If no action happens, lower it again. Now, if you're getting activity, you get 2, 3, 4 showings in a week or two, well, then hold a little bit. Maybe that's the right price. But if it doesn't happen, you don't get the showings, or the showings don't materialize into offers, keep dropping the price down. The idea is that over an approximate 90-day period, that the listing price will go from about 120% of what you think it's worth to maybe as little as 85 to 90% of what you think it's worth. And if we get an offer, and it could even be below the 85 to 90%, we will have empirical evidence to show the bank to support the offer that's being provided. We put it on the market. It's on the multi-list service. It's exposed to everyone. We had pictures taken. We did all these things, and the market said it's not worth that much. It's worth this. That doesn't mean the bank has to accept that, but it's pretty strong empirical evidence of what the property is really worth, and helpful in convincing the bank if there's a question about, wait a minute, this price is too low, it should be higher, then we've got some evidence to provide to the bank as to substantiate the offer that's been presented.
That's
Any other questions about short sale?
I've never been told to list at 120 at 120%. I think that's a very helpful thing, because it is true. They are looking for a path that was taken, and if it's not selling, it's not selling. Facts are facts. So that's very helpful.
And just to be clear, that's our recommendation. I mean, if someone said, well, Rick, I'd like to lower it by 4% every 12 days, I'm like, okay. It's really the concept of make sure you ask for more than what you think it's worth, and then lower it in systematic small decreases. But we leave that to the realtors to exactly how that should be done.
Great.
All right. Should I keep talking about short sales, or should I switch to probate?
Are you guys all good with short sales? Anybody have any questions? I don't see any faces. I only see a bunch of names.
Probate sounds good.
Probate sounds good. We've got thank you, Matt.
Matt, you must have never been involved in probate if it sounds good to
I
you.
haven't. 10 years, I've not had one yet. So,
well, probate is the court process of transferring assets from somebody deceased to somebody that's alive. And we'll speak in the context of real property, real estate, although I would entertain other questions if there were any. When somebody dies and they own a property, generally speaking, that property now needs to go through the probate process. Are there exceptions? Sure. If property is owned by more than one person and the form of ownership is joint tenants with full rights of survivorship, tenants by the entireties, those are 3 of our 4 forms. In all of those cases, the surviving owners own the house. The reality is that tenants in common is the most common form of ownership. That does require probate if one owner passes away. And we have many, many situations in which there is just one owner, which will require probate. Now, this assumes there is no trust. I'll come back to that, but this just assumes it's in your name. So I own a house.
Can I ask a question? Why is it that it's always tenants in common, or that's usually what you see. Like, why is it like that? When two people get married, is that just automatically what's done? Or I don't understand why.
Sure. Well, let's take a little side trip and talk about ownership of properties. Michigan has 4 forms of ownership of property that are recognized. We have tenants by the entireties, and tenants by the entireties is exclusive to a married couple. If you are not a married couple, you cannot own the property as tenants by the entireties. Tenants by the entireties is for the marital residence. It is unbreakable. It shields one spouse from the creditors of another spouse. When I say it's unbreakable by a creditor. However, if you get divorced, it's broken and you become tenants in common. The next form of ownership, tenants in common. It is the most common form of ownership. It is the form of ownership that is as to how a property is owned when the deed is silent. So if it says Rick and Brenda Lee, we own by tenant, or we own as tenants in common, even though it doesn't say it on the deed. Now, if I were lucky enough to have met Brenda Lee before she met her husband and we were married and it was silent and it just said Rick and Brenda Lee Linnell, then it would be tenants by the entirety. So if it's silent and it's a married couple, it's tenants by the entireties. Otherwise, if it's silent, it's tenants in common.
And so that's the thing, Leanna. If the deed doesn't reference what it is, it's going to be tenants in common. They're going to be tenancy in common.
Yeah, but
Unless it's a married couple.
isn't there joint tenancy? Like there's other.
He's got 2 more to go.
We're getting ahead. You're getting ahead of us.
He's got 2 more to go.
What's important about tenants in common is that each person owns an interest in the home, or forget home, the real estate.
Yeah.
And if that person passes away, so Brenda Lee and I own, I pass away, my heirs inherit my ownership position. So if Brenda Lee and I own a home 50-50, I pass away, my heirs become the 50% owner with Brenda Lee. Now, they only become the owner with Brenda Lee by going through the probate process, unless I've created a trust. That doesn't, not enough people do a trust. I'll go back to talk about that, but the vast majority of people wouldn't have a trust. And that means my heirs have to go to probate to acquire formal acknowledgement of their ownership interest of half of the home that I did own with Brenda Lee that she now owns with my heirs. What's important about tenants in common is it goes to your heirs, period. It never goes to the other owner. This form of ownership is breakable. So if Brenda Lee and I have some kind of spat, and Brenda Lee says, Rick, you are a terrible partner in this property, I want out. And I say, Brenda Lee, I think you're great. I don't want you to go anywhere. And Brenda Lee says, Rick, I'm done with you. And I say, well, I'm not done with you, Brenda Lee. Let's stay partners. Brenda Lee can take me to court. And she can have a lawsuit filed. It's called partition. Partition just equals court-ordered sale. And the court will force me to sale. And I could say, wait a minute, court, Brenda Lee's a jerk. I didn't want this. She's the difficult partner. It doesn't matter what I say. I could be the good partner. I could be the bad partner. The court will force a sale of the property. As a practical matter, what oftentimes happens is Brenda Lee will buy me out, or I'll buy Brenda Lee out. But if we can't reach some agreement, the court will have it listed with a realtor, and it will be sold to a third party, and the proceeds will be split by Brenda Lee and I. That will happen no matter what. Next form of ownership, joint tenants. Joint tenants means that Brenda Lee and I own as joint tenants. And what's significant about that form of ownership is I pass away, Brenda Lee automatically, by operation of law, owns my interest in the property. So if it's just the 2 of us and I pass away, Brenda Lee is the sole owner, period. Nobody has to go to probate. Nobody does anything. If Brenda Lee and I don't get along, and Brenda Lee says, Rick, you are an irritating partner. I want out of this joint tenancy. I say, Brenda Lee, come on. What are you talking about? I'm a great guy. Brenda Lee says, no, you're not. I'm done with you. Brenda Lee can go to court, just like we talked about tenants in common. She can do the same thing as joint tenants and sue for partition and force a sale, meaning a unilaterally the joint tenancy can be broken. And that's important to know. So in tenants in common, one party can break it. They don't need consent of all owners. Joint tenants, one party can break. They don't need consent of all owners. Tenants by the entireties, one party can break by getting divorced, which obviously means you don't need the consent of the other. The last form of ownership, joint tenants with full rights of survivorship. This is at its base a lot like joint tenants. If Brenda Lee and I own a property as joint tenants with full rights of survivorship, and I pass away, Brenda Lee inherits, just like joint tenants. Brenda Lee, same scenario, but we now own as joint tenants by or with full rights of survivorship. Brenda Lee says, Rick, you are not a good partner. Do not want to own this property with you. And I say, Brenda Lee, what are you talking about? I'm a great partner. Brenda Lee says, you're not, and I'm going to court to sue for partition. I want to break this form of ownership. And Brenda Lee goes to the court and then comes back and finds out it's not breakable. And that's what is so important for people to know. It is an unbreakable form of ownership, at least unilaterally. Now, if Brenda Lee and I agree, yeah, we're not good partners, we should sell this and we're the only owners, well, then you can break it. No problem. But if one of the owners, because I'm using the example of Brenda Lee and I, but you could have 4, 5, 6, who knows how many owners. If one owner is unwilling to break it, it cannot be broken, which means literally the last, I say man, but that's actually ridiculous. If there's a woman involved, it's going to be the last woman. Why? Because women outlive men. And she will be the sole owner of the property at some point when everyone else dies off. And there is nothing anyone can do about it. And it is critical to me that when buyers take title, if you're a married couple, there's nothing really to talk about. But outside of that, if you're buying with a partner, there should be a discussion on ownership. Who should have that discussion? In my opinion, it should not be the real estate professional.
Nope.
Why? Because the real estate professional, even though they might know everything I just said and more, and many, whatever, a lot of realtors know everything I just said. They know it just as well as I said it. Mm-hmm. But they cannot engage in the unauthorized practice of law. Moreover, and I'm sure nobody on the Zoom calls ever run into this, where somebody isn't exactly listening to what you're saying, or they're processing the information differently, or they heard exactly what you're saying, and then later they decided, boy, I wish I didn't own it as joint tenants for survivorship, and Brenda Lee must have told me incorrectly because I would have never done something so stupid unless she told me to do it. Even though, of course, you have notes from that time where you said, don't do this, and they still did it. The point is, you don't want to be in a situation where anyone could accuse you of dispensing legal advice. I would not, as a realtor, be providing this type of advice. As a title company, I would not provide this type of advice. And generally speaking, I don't think that title companies do. This is something for an attorney generally to talk about, or for the buyers to figure out on their own. It's all acceptable, but you do not want to be providing that advice because it can have unforeseen consequences. And we see those cases regularly where people are in forms of ownership that they cannot get out of. I will tell you that it seems to come up a lot in two instances. One, you have somebody who's a little bit older and they start thinking about, well, what if I'm not here? And who do I want to get my property? And they'll add a child or a grandchild or a nephew or someone else to the title. That is a terrible way of accomplishing estate planning. And people say, well, it's cheaper, and I don't want to talk to an attorney. And I'd say, generally speaking, it's not cheaper. It might be cheaper to produce the deed versus an estate plan, but in the end, it will not be cheaper.
There's a question. There's a question here. It's from Tammy. She says, is it okay to have a quit claim deed adding me to my dad's house? Have it notarized, but not recorded until death?
Yeah, that's what I wanted to ask too.
That's a good question.
Well, is it okay? Sure, it's not against the law, but and this is no offense to Tammy, but if I'm her dad and I want Tammy to own the house when I'm gone, I do not prepare a quitclaim deed, because when I sign that deed, Tammy's now an owner. Whether it's recorded is irrelevant as far as Tammy and I are concerned, because I gave her an interest in the property. Recording it just puts the world on notice, but Tammy and I know it exists. And so now Tammy and I get sideways with each other. Well, Tammy's an owner. I want to sell the house. Not unless Tammy says, okay. I want to get a mortgage on the house. Not unless Tammy says, okay. And if you say, well, why do I have to tell the lender, Rick? It's not recorded. Mortgage fraud. So there's unintended consequences. If I want Tammy to get the house when I'm not here, I do a ladybird deed, or I talk about doing a trust, one of those two, because then if I, God forbid, I don't make it home from work that day, Tammy's going to get that property. But while I'm upright and walking around this planet, I get to make any decision I want. What if I want to sell the house later? What if Tammy, marries somebody I don't like? What if Tammy starts making terrible financial decisions? What if Tammy, and I'm using Tammy, but not that I believe any of this would happen, but what if Tammy, is texting while driving and hurts somebody, kills somebody? She gets sued. Well, what are her assets? My house. And so to me, it is a terrible, we call it a will substitute or an estate planning substitute. It is a terrible, terrible idea. There are ways to effectuate exactly what Tammy's dad wants. It might cost a little bit more upfront. I mean, we're talking like $100 more or $200 more, but it leaves the dad with all of the control. But the outcome is the exact same when Tammy's dad is no longer here.
So it's called a ladybird deed.
Correct. And a ladybird deed is sometimes referred to as an enhanced life estate deed. It doesn't have quite the same ring as ladybird deed, so people like to say ladybird deed, but it means the same thing. And it's a deed in which the current owner reserves a life estate for themselves and then provides for a contingent remainder interest to whomever they want to leave the property to. And why is that distinguishable from the quitclaim deed that Tammy just asked about? And the reason is that in a ladybird deed, it's a contingent remainder interest. What does that mean? Well, that means that if Tammy's dad decides, I want to sell the property, I want to mortgage the property, I want to, deed my interest to somebody else, with me. I found a new person in my life. I can do any of those things, and I do not need any agreement from Tammy. I decide I don't like Tammy. I like my other child more. I can get rid of Tammy and add my new child or my other child on there. I can do whatever I want, and I don't need Tammy's approval. Whereas a quitclaim deed, putting from myself or from Tammy's dad, to Tammy and her dad, so they're both on it. Now, Tammy is part of every decision. And if Tammy doesn't agree, then the dad could take Tammy to court, assuming it's not joint tenants with full right survivorship. And he could take his own daughter to court and sue her to force the sale of the property, and she'll get some ownership interest or some money from the house. I don't know too many people that are interested in suing their children, not to mention the cost of paying an attorney. And all that could have been avoided with a simple ladybird deed. Let's see, what was I saying about joint tenants? Oh, I know what I was going to say. So the forms of ownership, if you're married, it's tenants by the entireties. If you and a buddy are buying a house uh, I
Just me, or can I not hear Rick?
live there, to rent
Here we
it,
go.
do whatever, tenants in common.
Yeah, he's breaking
The
up.
joint tenants and joint tenants sports of survivorship is often brought up when you're moving.
I know your voice, you know, there's a lag that's going on. There's a lag, very choppy.
Is it still choppy?
Oh, that's good. Oh, I don't know. You're in and you're out. There's another question for, oh, lost you completely now. How does one obtain a ladybird deed?
Well, it's just like any deed. You have someone prepare the deed and then you record it, execute it and record it. Did that end? Can you hear me?
Does
We
that
got
have to be done by underwriters or a title company?
What was that?
Does that have to be done by a title company or underwriters?
No, but I would recommend having an attorney do it. It doesn't have to be done by an attorney, but typically you want an attorney to do it because you want to have the consultation to make sure it meets the desires of the party who's doing it. You know, most people, if they say, I want a ladybird deed, you say, well, do you know why? And some people have done the research, but most people say, well, I think it's what I want. But really, you want that consultation to talk about, well, we could do this, we could do that. You know, what are you trying to do? And here's why I think you should do this or that. And then the person makes a really informed decision. And then you have a deed prepared.
That makes sense.
Thanks, Rick.
You're welcome. We see the joint tenants and joint tenants with full rights of survivorship being considered for estate planning. It's usually a bad idea. There's so many other ways to make that happen for an estate plan that cost a little more upfront, but in the long run are much cheaper and allow you to retain all the control. But the other thing we see is when there's cohabitation. So a committed couple, not married, but committed to each other, purchase a property together. And we will see people take ownership as joint tenants, or more commonly, joint tenants with full rights of survivorship. And they don't realize that if that relationship breaks down, that there is no way to break that ownership unless both agree. And this doesn't happen always, but typically one person, when a relationship breaks down, doesn't want to be around, and the other does want to be in the relationship. Or neither's getting along, but one wants to use it as a weapon against the other and say, well, I'm not going to agree to sell the home, and there's nothing you can do about it. And you know what? That's correct. There's nothing you can do about it. And so joint tenants with full rights of survivorship I'm not saying it's wrong. It's just the implications of that form of ownership need to be completely understood by any parties considering that. And most people, when they understand it, will not do it. It's pretty rare, if they understand how it works, that they would actually want that form of ownership, because there are other ways to accomplish their goals that aren't as committal as joint tenants with full rights of survivorship. I would also say, regarding cohabitation, anybody who's going to buy a property with a significant other, you should enter into a cohabitation agreement where you talk about who's putting what down payment, how are the costs going to be split when you're there, what happens if one party wants to dissolve the relationship, how do does one get to buy the other out, what happens if one passes away, do you want that person, the other person, to inherit it? That's typically not what we see if people have children, or if they're a little bit older when they do it. They want someone to inherit outside of that person. Not that they don't care about them, but each person kind of has their own assets. But we'll see where one person passes away, but they want it so that the other person has a life estate, that they get to stay in the home as long as they pay the taxes to maintain it. And when they vacate, whether it's by death or just by choice, then the property is sold, and then the person that passed away first, their heirs then get their half. But those are things to consider in a cohabitation agreement. But anyone buying together as a couple should absolutely get a cohabitation agreement to save yourself a lot of grief and fighting if the relationship does not last the test of time.
One
All
of
right.
my sellers, if this, just to like circle back to my original question, one of my sellers right now, he actually, we're going through probate because him and his mom owned it, and they were tenants in common. So, 50% of the property's interest would go to his brothers, all of his brothers. And so we're trying to get that straightened out right now. Actually, we're working with Bunny. She's helping us with it.
She's
And-
amazing. Isn't she amazing?
Yeah, she is really good. I was just wondering though, like, why wouldn't he? I guess the answer to the question is most people don't know the different types of tenancies, but if somebody did know, and why don't people just have that written from day one and done in the title work or on the deed, where somewhere that it says we have a cohabitation agreement, or we're doing joint tenancy with full rights of survivorship? How come people don't just do that? Because then you don't have to worry about probate whenever somebody passes away. You know that that's what you want to happen. Do people ever do that? Why is it so common that everybody's tenants in common and needs to go through probate? Is it just because people don't know, or is it because title companies don't tell people, or because people don't use lawyers? I don't know why people, it's crazy going through probate. This has been taking so long. And if that stipulation would have just been on, and his mom would have signed that, he would have been like, she would have been cool if she was alive still. But now we have to involve his brothers and all this other stuff. They didn't even live there.
Well, you want me to answer the questions that haunt the universe and mankind, and I cannot answer those questions. I don't know why people don't do it. I mean, I think the obvious reason is somebody didn't tell them, because if they knew, they'd say, well, of course I would do that. Say, why did you do that? And say, because I didn't know. No one told me that.
So if you don't see anything, does it just automatically it gets written as tenants in common or tenants?
Well, it doesn't. It
entirety
is.
That's right.
It's not that it gets written as tenants in common. People don't realize if it's silent, that's what it means, and they don't know what tenants in common means.
We don't
And
know what any of the tenancy are, but it defaults. If it's not written, the default is tenants in common.
I mean, I can tell you.
Yeah.
So I wrote a cohabitation agreement. I don't know, maybe 4 months ago. We write them all the time, but one in particular. And I talked to the people that were buying it, this couple, and we went through the forms of ownership, and they said, we think joint tenants, that's the way we want to own it. If one of us passes away, we want the other to get it. If the relationship breaks up, then we still can break up the ownership. And I said, okay, great. And they said, we just want you to, they're buying it, with a mortgage, et cetera. The title company's taking care of it, which is great. So they pay me for my time to consult with them. And they call me back and they say, hey, Rick, we talked to the title company and they said that there is no such form of ownership as joint tenants. They think that you forgot to say joint tenants with full rights of survivorship. And I said, no, I didn't forget to say that. I said, we talked about that. They said, yeah, we remember you talking about that, and they're different. So could you call the title company? And I say, okay. And I'm thinking to myself, did I say something wrong? Am I using the wrong words? Is my brain, going soft on me? And I called the title company, and very nice woman at the title company that they were dealing with. And I said, I talked to my clients, and they said that they talked to you, and they said they want to own it as joint tenants, and you would advise that that's not necessarily a form of ownership. She said, yeah, did you mean joint tenants with full rights of survivorship? I said, no, I meant joint tenants. And she said, well, that's not a form of ownership, is it? And I said, well, yes, it is. And she said, huh. She said, let me check with my attorney. So she gets off the phone, calls me back 20 minutes later. She said, I never knew that joint tenants was a form of ownership. She says, I've been doing this for 15 years. I had to ask the attorney. I thought you were wrong. And the point being that even someone like that, who's in a position where you'd think they would know about it, or at least had seen it, hadn't seen it. And people just aren't aware. So back to your question about why do people own as tenants in common, et cetera, people just aren't aware. They don't know. And the system is not set up for them to receive that kind of consultation. And so you get these situations that occur.
So what would somebody do if later down the road that they realize that they want to have something drawn up like that? Was there some type of an addendum that an attorney would write to?
Well, kind of like that. They would have an attorney
title?
draft a new deed
Just
that
draft.
reflects their wishes and their intents. So you just, the two owners sign a deed, and it's no longer joint tenants for its survivorship, it's joint tenants, or it's no longer tenants in common, it's joint tenants for its survivorship, or it's, instead of tenants in common, it goes to one person who writes a ladybird deed. It's whatever's appropriate.
Yeah.
Correct.
Yeah. Is a trust the same thing as a will?
No, a trust is, to me, it's the best analogy is if you have a rental property and you say, okay, great, I got this rental property. Rick, I understand you deal with people that own income properties. What should I do? And I say, well, you're definitely going to want to put that property in an LLC. And you say, why do I want to do that? Well, you're going to want to do it for liability purposes, etc. And you say, yeah, but I want to own it. I don't want a company to own it. And I say, well, technically you won't own it, but you'll own the company that owns it. And you're like, oh, okay. Well, a trust is different reasons, but it's kind of the same thing. And that is, a trust is a standalone entity. And so if I deed my home from my name to my trust, which I've done, then my trust owns the property. Now I'm the trustee of the trust, which is like being the owner of the LLC. I can sell the home even though it's in the trust. I can mortgage the home even though it's in the trust. I can repair it. I can rent. I can do whatever I want with the home as the trustee of the trust. But the significance is I don't make it home from work today. I die. Probate is the process of transferring assets from somebody deceased to somebody that's alive. I die, but I don't own the house. The trust does, and the trust doesn't die. And the trust, therefore, avoids the probate process. It has specific directives as to what's to happen when I die as the trustee, but it never goes to probate. And so it goes exactly where I've directed it to go.
I had another seller who were selling her dad's house, and he passed away, and they have a quitclaim deed and a will. Is that enough? Like, is that going to be sufficient enough for them to sell? And
Well, the will is,
interest.
the will is a great starting point for an estate plan, but a will does not avoid probate at all. But the will says what the person wants to happen. And the deed, depending on what it says and assuming it's properly done, the deed could be recorded. And if that then conveys the property into the name of whomever is to get it, then it's possible that avoids probate, but you have to see what the deed says.
Yeah, there's a type of deed that's like all encompassing. I forget which one it is.
What do you mean all encompassing?
Like, I mean, it's like got the most benefit.
That's something you have not heard of?
No.
It has like the most benefits. I don't know. This is all pre-licensed.
Well, to me, a deed, it to have the most benefits, it depends on what the scenario is.
It's like a
I mean,
warranty deed. Isn't that what it's called? A warranty.
Oh, a warranty. Well, that's not a quick claim
got
deed.
it. That's what
A
I'm talking.
warranty deed and a quick claim deed, the difference is a warranty deed is the grantor is warranting that they have clear marketable title. In a quick claim deed, the grantor is saying, you're
Okay.
getting whatever title I have to the extent I have any title. But that doesn't have anything to do with avoiding probate or not avoiding probate.
Thank you.
No problem.
So if you have a situation where, the one parent, two or three kids, parent passed away, never had a will or anything, is it pretty much guaranteed that's going to probate, or can the kids
Not
basically?
pretty much guaranteed. It is guaranteed it's going to probate.
Okay.
It's 100% guaranteed.
And if
it's going to probate.
they just have a will stating I want all three kids get 1/3 ownership, that will, just one individual, one parent on the deed and all that, does that avoid the probate then?
No, a will still goes to probate, but the will makes it easier in the probate process, easier meaning cheaper and faster, but it does not avoid it. Only a trust would avoid probate, or some deed like a ladybird deed, for instance,
Right.
then it would avoid probate.
Okay.
Great questions.
I don't know if we have more questions. My phone is.
No, you have no questions right now, so you can carry on.
Well, what time are we at? Because my phone is getting really low and I don't know why it's going so.
She booked it for 2 hours, but that's okay. It's 7:20, and we do have a
2
question.
hours.
We do have a question on forbearance. And then we can let you
Okay.
go.
Okay, so forbearance is it's a generic term that means that a party that is entitled to something, like a lender, agrees to modify the terms. It's a practical matter. A lender in these times, for people that have been impacted by COVID financially, I mean, everyone's been impacted to some degree, but some people have really taken the brunt of it financially. A lender may agree for a fixed period of time to not require any payments or to require half payments. A forbearance agreement should be in writing. It should be noted that in many instances, a credit reporting agency or a new lender will view as derogatory to their credit report, meaning way. If you're losing your home and you can't afford to pay, and you're a performer, you're a waiter, you're a bartender, and you say, I'm worried about losing my house, and until COVID goes away, I can't work. Well, then you're not so worried about your credit score, you're worried about keeping your house. But they should not be entered into willy-nilly. And I'm not saying there's anything wrong with them. They can be extremely helpful tool to save your home, but there are ramifications. And so, first of all, they've got to be in writing. Secondly, the writing should be very clear about what the terms are. If possible, I would try to negotiate that this will not be considered derogatory credit. Now, granted, the lender can't really make that decision. The credit reporting agencies do, but that it won't be reported to a credit reporting agency. I try to negotiate that. I can't tell you that that's always going to work, but that's at least what I try to do. And the other thing to understand about a forbearance agreement is typically forbearance agreement, so you don't have to pay your mortgage for 6 months. Oftentimes, I've seen forbearance agreements where in the 7th month, you owe the 7th month plus the previous 6 months. And a lot of people will say, well, that didn't really do me any favors. I need you to put that on the back end. Now, that would be, from a classification standpoint, that would be a mortgage or loan modification, where debt is not forgiven, but moved to the end of a mortgage rather than just a short forbearance period. I don't know if does that answer your question?
So I have a question. So
Yeah.
if somebody were to want to negotiate this forbearance situation, is that something we send your way, or do we tell them to call the bank, or how would you say we would go forward with that? You said yes.
We do it all the time. I mean, some people will go straight to the bank. Oh, yes, we do it all the time. We negotiate them. Can you hear me?
Yeah,
can you hear me?
Yeah, you're sort of going in and out,
Oh.
but.
Let me see if I can get back to the spot in my house where we negotiate them all the time. But people can call the bank on their own. It's like a short sale or loan modification. People can do it on their own. I think it's dangerous, not because the bank's not looking out for their best interest, although I don't believe they are, but it's really to make sure you appreciate what, in fact, you're doing or might be doing based on the terms of that agreement. And the vast majority of people don't appreciate what the agreement means and aren't cognizant of the possible negative impacts that could occur.
Yeah. Got it.
Yeah,
Yeah.
does that hurt your credit too, going into forbearance?
Generally, it's considered derogatory credit reporting, so it will have an impact.
What do you think will happen when the mandates lifted, or whatever? What is it called again? It's just, where that
The
starts.
moratorium on foreclosures?
Yes. What happens if people can't pay?
They're going to foreclose. They're going to take their homes back.
They go right into foreclosure, or will they have the option of short sale, or they could
Oh, they'll
try?
have the option of short sale. Foreclosure takes, I mean, usually banks, to me, there'll be at least a 90-day period of time where banks are getting themselves together. Then you'll see foreclosures start to occur. But short sales generally can be done at any time, before the share sale or after the share sale, preferably before, because there's less of a credit impact, but there's time to do a short sale. It's just, unfortunately, it's tough as a homeowner doing a short sale. It's oftentimes hard to come to grips with the fact that this is what you're going to do. And we see people kind of paralyzed by the fear, which is completely understandable, and they don't do anything. And then they run out of time, and all of a sudden they call you and they're like, hey, can you do a short sale? And you're like, okay, sure, tell me the situation. Well, I had a share sale 5 months ago. Well, that means you only have 1 month of redemption left. I know, can you sell the house? Well, that's not very realistic at that point. We've done that. We've had some Hail Marys that work,
Yeah.
but not very realistic at that point. So it's really about people, and it's tough. I mean, when you're in a compromised financial situation, it's very difficult to do this, but it's really about people accepting where they're at and saying, okay, I got to do something.
May I ask one more question? I know I asked
Sure.
questions, but I wanted to know, because I get asked this a lot lately. What is the process of evicting tenants right now because of like COVID and everything? Like, how much notice does a landlord need to give a tenant right now? And what if it's due to COVID that they can't pay the rent?
Well, eviction based on not being able to pay the rent can't be done right now. Although the moratorium ends tomorrow, could be extended. But if the eviction is for some other reason, it can be conducted. And what you'll see is many landlords who are proceeding with evictions based on leases that have expired, and they're just terminating the lease because it's expired. At least formally, that's what they're saying, even though the real reason is because the person's not paying rent.
Okay, so they can do it if the lease is expired. That's right.
Yep. This is true.
30 days or 40 days? They have to give.
It'll take about 45 days to, you got to give a 30-day notice to quit because you're terminating the lease, not because of failure to pay, but just by expiration. So it'll take, you got a 30-day notice, and then it'll take usually about another month to evict them.
Okay, so like a 30-day notice that you're terminating the lease, and then another like 30 days, 45 days to actually.
Correct. To physically have them removed from the property.
Gotcha. Okay. Thank you
You're welcome.
so much.
Well, let's wrap it up with that, Mr. Rick, shall we?
Yes. Plus my phone's about to die on me. So thank
know,
you. I appreciate it.
I don't see your face anymore, but that's okay.
Yeah, my phone stopped doing it. Stopped communicating.
We appreciate your time more than you know. Thank you so much for sharing. Have a wonderful Easter. And
Thank you.
We'll see you soon, I'm sure, at some point.
I'm looking forward to it.
Thank you.
Take
Bye,
care,
everybody.
everyone.
Thank you. Happy
Thanks very
Easter.
much.
Bye.
Thank you. Bye.